Good evening,
Good evening,
all.
everyone.
Oh, sorry. Go ahead, Ms. Archer.
Go ahead, Miguel, you could speak.
No problem.
Good evening.
Good evening, everyone. Welcome to our Mastering Mortgages program. Glad you all joined. For those who don't know me, my name is Miguel Pratt. Your lecturer is Ms. Christine Archer. And your other lecturer will be Mr. Glenn Nordage. And hopefully everybody has got the schedule for the 10 weeks. We will be doing our exam on a Saturday at the Institute. We will practice social distancing at the time. Please use this link for all classes. So if you don't see a link from me 1 week, just refer back to this email or save this link somewhere on your desktop. And it'll be the same access for every week. If you have any questions, please feel free to contact me, send me an email, give me a call at the Institute. All classes will be recorded, and I will show you how to get access to these classes. That all done and said, I will turn it over to Ms. Christine Archer, who was your first lecturer for the first 3 weeks.
Okay, good afternoon, everyone, again.
Good afternoon.
Good afternoon, Ms. Archer.
All right,
Afternoon.
good afternoon. So, did you have the opportunity to read just the introduction in terms of what the course is all about?
Yes.
Okay, all right. So let's start with module 1. So module 1 is an introduction. So it more or less tries to help you define what the terms mean in land law. So this course, at least this section so far, will cover quite a few pieces of legislation. So it covers the Conveyancing and Law of Property Act. It will cover the International Persons Landholding Act, the Registration of Records Act, Real Property Tax Act and all of the amendments, the Stamp Duty Act, the VAT Act and the regulations, Quieting of Title Act, and the Borrowers Protection Act. There's quite a few pieces of legislation that covers land law in the Bahamas. Any questions so far?
Nope. No questions.
Oh, wonderful.
Very good.
I love to hear that. We're good. And which I left out? I left out the law of property and conveyancing. All right, so when you talk about property, property means ownership. And ownership means that in the land, and law land means that you have rights. So property means that you have rights to land. It means that you own it. But when you speak about ownership, ownership again means the right of a person to enjoy property to the extent of the law. Or ownership can mean you having a right to assert to someone else that you own this land. And it also could be asserted against other people who come to claim the land. So it's always said that ownership has 3 rights: the right of using it, the right of profiting from it, or the right to use it up. So the right of using means that you have exclusive use of that property. You don't have to use it yourself, but you could prevent others from using it. Profiting from it means that you can rent it out or you can use it in some form whereby you can make money from it. And using up means that you can transfer the ownership to someone else by sale or by gift. So ownership, you can lose possession of it, but you don't lose title to it. So losing possession means that you lose the physical control of the property, but doesn't mean that you actually lose the title to it. Everybody understood that so far?
You said the use of it is by sale or by, I didn't get your last part.
Sale or gift.
Okay.
So no questions on what property is and what ownership means.
No.
Okay, all right. So then let's look at other rights. When you talk about property, property has classes. And ownership of anything is having a right to that thing. So you could own a right over or against a thing owned by someone else. And those property rights include easements and profits. So everybody knows an easement is a right over a piece of land that attaches to another for their benefit. A profit is a sort of easement. It's the right to go onto another person's land and diminish it by taking something away. And another category of property right is restrictive covenants. So that's a covenant by one landowner to another to continue to be enforceable and against all of the future successors entitled. So then the next thing that you need to be able to define is what is title. So once you have title, then you have ownership. And in property law, you always concentrate on possession. So a person who said that they have been dispossessed of their land, they don't have to prove that they were the true owner. They only have to prove that they had a better right to possession than the person who was claiming it. And normally an earlier right to possession is a better right to possession. So then the law then defines what is possession. And possession is having exclusive use and control of an item of property with no rights or title to that property. That's what possession means. Exclusive use and control, but no rights or title to the property. Now, possession may be evidence of ownership. Maybe. But a person who is in possession may have continuing physical control over the property.
Excuse me, Ms. Archer, you said that possession is exclusive use and control, but no rights of what? I didn't get the word.
No rights or title to the property.
Oh, no rights or title. Okay, thank you.
Yes, no rights or title to the property.
Hi,
Hi,
I have a question.
go ahead.
Okay, so like you said, possession is defined as exclusive use and control of an item of property, but no rights or title. Can you explain how can one possess or take control of a property without owning it? Is that like squatting? Is that, I mean,
No, this is just you living on a piece of property. If you living on a piece of property, that doesn't mean that you have title to that property.
Okay, so you mean like in terms of what, like renting or leasing it?
Yes. Uh-huh.
Okay,
Yeah.
okay.
Mm-hmm. So when you deal with land, the purchaser always wants proof of ownership. And that means the vendor has to provide the proof by producing the title deeds in the form of a certificate of title. The title deeds demonstrate the strength or otherwise of the vendor's title. It also demonstrates his right in possession. And it also allows the purchaser to ascertain whether there's any risk that someone else could come behind with a better claim of possession. So whenever you talk about ownership, ownership can mean ownership of many different things. And so it's not only land that is capable of ownership. So when you talk about clothes and tool and food and books, cattle and horses, those things are called chattels. And then over time, other things are called ownership, such as intangibles. So when you speak about, hold on 1 second. I have my pages mixed up in reverse. So when you speak about classification of property, property is divided into real and personal property. Real property is freehold interest. Personal property is divided into chattel real and chattel personal. Chattel real is leasehold interest. And chattel personal, cars and boats and jewelry and furniture. Any questions?
A quick question. You said for the classification of property, it could be chattel real, R-E, how do you spell it, R-E-A-L?
Uh-huh,
Okay, and then the other one would be chattel personal.
right.
Okay, thank you.
Now, chattel personal can be further broken down into choice in action and choices in possession. So choice in possession means personal property. Books and clothes and computer. Choices in action is property which do not physically exist and cannot be more or less possessed physically, such as checks and copyrights. Another example of choices in action would be when a bank holds as security your insurance policy or shares in a company or shares in registered stock. Those are choices in action. So we start back from the very first set of definitions. We first say in land law, you have property. So you purchase a piece of land, 100 by 125. You say you own that property. But you do not actually own that land. You own the interest in that land. Do you understand what that means?
No, I was just about to
No.
ask that. No,
Mhm.
ma'am.
No, that doesn't.
Okay. How many of you own a piece of land?
I do.
Yeah.
You do? Okay, all right.
I
So
do.
all right, so you own a piece of land. Do you have a mortgage on it?
Yes.
Okay, so we haven't gotten to the mortgage yet. You own a piece of land. That piece of land you own and your title deeds to that speaks to your interest in that land. The land is owned by the crown. That's why the government can any day decide that they make an announcement, they're running a road through your property. You only own an interest in land. So your ownership gives you a right to enjoy your property. So you purchase a piece of land, you will wall it in, you want to fence it in, you want to put a house on it, you just want to plant some peas on it, you want to raise horses on it, whatever you want to do, as long as it is what the law permits. So if the land is zoned for farming, you can farm on it. If it's not zoned for commercial property, then you can't put a commercial building on it. So you have a right to enjoy your property to the fullest, as long as it is within the law. And your right can be asserted against anyone who wants to come against you to say that they own the property. So by you having your ownership, which is your right in that land, you can profit from it. You can transfer it to someone else, or you could just use it. By you owning it, you never lose. You could lose your possession of it, which means you may not be on that land yourself, but that doesn't mean you could lose your title. You understand what that means?
Expand on that, please.
Okay, so you have a piece of land and you decide you're farming on it, or you decide you're building a house on it. You have possession, you are there. You have exclusive possession to that land. You could actually decide, I don't want to be on this land anymore. Purchase another piece of property or lease from someone else. You have lost the possession because you're not there, but you have not lost your title. To lose your title, you'll have to sell it.
Gotcha.
What you said just not Jess.
No, I was saying I got what you were saying.
Okay, all right. So,
Ms. Archer, does one ever own the land itself, or are
No,
we just
no.
owning the rights over it?
You only have rights.
Oh, wow.
You only have rights. You have rights over your land, and then you could have interest in the land.
So you're saying that the state or the crown owns the land itself.
Yes. And when you purchase your rights in the land.
What's the difference between rights and interest, Ms. Archer, please?
The interest comes about when you then decide that you want to either transfer or you want to obtain a mortgage. So we're going to do interest in a few minutes. But I wanted to make sure you understand first the rights that go with ownership and what title means.
So let's say this, right? Because you had said an example before, if the government say they want to put a road through your land or your property,
Mhm.
having rights over it and possession of it, can you fight back, or how would that work?
The probably love to file a petition, but they have that. They can do that because they own the land. You only own an interest, so they will give you fair market value.
Oh, okay.
That includes the transformers they put on the line.
Well, I don't know about all of that.
Just saying. Okay.
I don't know about that.
Hmm.
I believe in that. In that case, I think BPL would have to pay something.
Oh Lord.
I know.
Oh, I don't know. So your ownership is in your title. So once you say you possess this land where you have a title, that possession means you have exclusive use and control. And you normally have that with your certificate of title. Now, land. We did property, classifications of property, now land. Land means real property. The building and the rights over the land. It doesn't include the fixtures, the paintings in your house, the peace trees in your yard. That's what land means. The building and the structures on the property and the rights over your land. And land could be realty or real property. And that's distinguished from personality or personal property. So when we speak about land law, you're talking about the rights over the land rather than the land itself. So when you go for a mortgage to a bank, what you do is you mortgage your freehold land as security. So you give the bank the right of security over your land. And you do that by giving effect to either a legal mortgage or an equitable mortgage. So only the land is not affected. Only the rights that you have over the land is affected when you get a mortgage. So you have legal and equitable rights. Your legal rights may either be a legal estate or a legal interest. A legal estate is a right of ownership, and you are entitled to possess or occupy the land. A legal estate could be freehold or leasehold. So when you purchase a piece of property and it has a clear title and you've paid for it in full and it's transferred into your name, then you have a freehold estate. And you own that in fee simple absolute in possession. Which means that you have both legal and equitable interests in that land. So or by will. or under the rules of intestacy. Absolute means that it is unconditional, and in possession means that you as a freeholder, either you're in possession or you have the right to receive rents. Because remember, you have a right when you own land to profit. So do you understand what freehold estate means? Yes?
You can explain it again for me, please, Ms. Asha, freehold estate?
Okay. So freehold estate means that you have purchased a piece of property and the property has been conveyed in your name. So you've gone through the whole selling process. You have your certificate of title. Freehold now means that you own that property in fee simple absolute in possession. There's no superior tenant to that property. You are now the owner of that piece of land. So that means that once you own that property outright, you have both a legal and an equitable interest in that land. Fee simple means that your land can endure indefinitely. Fee simple means that you can pass that, you can sell it to someone else, you can give it as a gift, you can include it in your will, or if you die without a will, you can still have the property pass on to someone else because you own it. Fee simple, absolute in possession. Absolute means it is unconditional. There's no other person claiming title to that property. And in possession means that either you are actually in possession of the property or you have a right to receive rents. And I said rents, remember, is one of the 3 rights that goes with the land when you own it. The next legal estate is you have a leasehold estate. And a tenant derives the estate from a superior tenant who may be a freeholder. So there are 2 ways you could be a leasehold estate. 1, you own the land and then you decide to lease it out to someone else. So if you own the land, fee simple, absolute in possession, you can lease it out to tenant number 1 for 20 years. Tenant number 1 can lease it out to someone else, but it cannot exceed the duration of his leasehold. So he can lease it out for 15 years. The third person can lease it out for 10 years because it cannot go beyond the lease for the very first lessee.
Which is the 20.
Is there a limit on the number of parties that it can be leased?
No.
Mm.
So the freeholder still has the freehold interest during the continuance of the lease because he still owns that property. He's just leasing out the time in the property.
That is the agreement between the freehold person and the person who's leasing the property.
Yes, so it's called a lessor and a lessee.
Okay.
Yeah. So a leasehold is termed is referred to as a term of years absolute because they have a fixed term. And it operates by contract, so it's by law. And normally if you want to use your lease as a security, it's normally done on fixed term leases. So an interest in land can be legal or equitable. Legal interest is a right over land which is given to a non-owner, but it's still valid against everyone. And it gives that non-owner a right which is less than actual possession, as in a legal estate. And I give you some examples here. An easement, a charge by way of legal mortgage, a charge imposed on land by law, or right of entry. An equitable interest are legal rights which are valid against anyone who has notice of such rights, whether it's actual, whether they actually know it, or whether it's constructive, such as at the time when they make the purchase. Equitable interests are equity of redemption, which is when you have a mortgage, that's a right to redeem your mortgage property. An equitable charge, that's when interest in your land is taken as security for a loan without creating a legal mortgage. And of course, restrictive covenants. That's when one person promises to restrict the use of their land for the benefit of another person adjoining it, adjoining land.
What is that restricted?
Covenants.
Okay, thank you.
Some land have restrictive covenants in it. So in law, you could have both legal and equitable ownership of a legal estate in land. So the legal ownership gives legal title to the estate, and the equitable interest in land gives the right to benefit from the estate. And it is possible for one person to be recognized as the legal owner, while another person can be the equitable owner. And you see that when you have trusts of land. Everybody knows what a trust is, right? By definition.
No, can you
No.
explain?
Yeah.
Okay. All right. So a trust is the legal arrangement where an individual, be that person, what you call a settlor or a donor, agrees to transfer both their legal and equitable interests in their properties to a trustee who will manage, administer those properties for the benefit of the beneficiaries. Once that settlor transfers those assets to a trustee, he no longer has any interest unless he himself becomes a beneficiary. The trustee takes the legal interest and the beneficiaries take the equitable interest. So in a trust arrangement, the legal and equitable interests are separate. The settlor who owned the property, before he entered into that contract, he disposes of his interests, both interests. Understood? Or still clear as mud?
One question, Mrs. Archer. So
Okay.
if let's say, I guess a trustee wants to regain rights to whatever the property or whatever the case is, could the trust agreement be rewritten so that they could be noted as a beneficiary so that they can have that right back, or how would that work?
What you mean? Say it again.
Like if a trust is set up for beneficiaries, but I'm the person who would have set it up, like let's say
Okay.
it was my property initially, and
Uh-huh.
now I want to make changes to that. Would I have to become a beneficiary, or is there another way to make changes to it, to the agreement?
Okay, so it depends on the type of trust you create. You can create a revocable trust. But in most instances, if you want to retain that power to do that, then you're gonna have to be a beneficiary.
Okay, so if you set up a revocable trust, then you could go ahead and make amendments to it.
Yes,
Okay.
because you could revoke the trust and then do a brand new trust.
Oh, okay, okay,
Yeah.
okay.
So
Clarif-
right. So normally a revocable trust is used more like in a business structure. If you're doing it for wealth management or for succession, it's normally irrevocable.
Okay,
Yeah.
thank you.
And the trustee uses his discretion. So that's how you have different types of ownership, legal and equitable. So when you mortgage your property, the bank takes your legal interest and you keep the equitable interest. That's what the mortgage does. So there are two types of ownership in land. You have joint tenancy, and then you have tenancy in common. So joint tenancy, the key to that is what? What's the key to joint tenancy? The key to joint tenancy is the right of survivorship, which means that if you and your sister both own the property as joint tenants, when one dies, the one automatically takes the whole interest in the property. If normally for joint tenancy, you can't have more than 4 persons. And a tenant can't sell or mortgage their legal right because it can't be severed. But they can sell their equitable right or mortgage the equitable right in the land. A tenancy in common means that there is no right of survivorship. So when one person dies, then their personal representative then, based upon whether they die testate or intestate, makes a decision as to who will obtain their portion of the land. So you know what testate and intestate means? Yes?
No.
No,
Oh, okay. No, okay. No, what happened just now when you said no, the phone just said OPA, and I wasn't sure. Okay, so when a person died, when they die, they can die prior to by writing a will, or they can die without writing a will. If you die with a valid will, then it's said that you died testate. And the next word I have to explain to you is personal representative. Personal representative is a collective word that is used for the person who would administer your belongings when you die. So under the umbrella of personal representative, if you die with a will, that is said that you died testate, and then you would have an executor or an executrix, so female, to administer your will. If you died under personal representative without a will, then it said that you died intestate. Intestate means that then you have to follow the laws under the Inheritance Act. And the person who will carry out the administration of your estate is called an administrator. That person cannot act until the court says so. An executor can begin from the date of your death. So that's what it means when it says tenancy in common, there's no right of survivorship, which means that when that person dies, whoever's their personal representative then has the responsibility to see who will inherit that piece of land. Any questions? It's clearer now?
Yeah.
Okay,
Yeah.
all right. So land registration. So everybody knows in the Bahamas, we have unregistered land system. And you know that a person owns a piece of land after you've seen their title deeds. And that's the abstract of title, the conveyances, the mortgages, release of mortgages, the searches, assignments, and all of that. So in an unregistered system, the owner of land transfers his ownership by deed, which is a written transfer. And normally, the title is investigated.
Question for you, Ms. Archer. Why is it called an unregistered system?
Because in some jurisdiction, the land itself, trying to find out who owns a piece of land is just keying in the person's name or keying in the land, and it will tell you who owned the land. It's automated. All of this that we go through here in terms of trying to find good title, where the lawyer takes 6 months or 8 months trying to get to the root of the good title, in other jurisdictions, it's automatic. So that's why it's called unregistered. It's not automated. It's all manual.
Okay.
Yeah. There've been argument and debates over and over again to have a registered system, but it's never moved.
Wow.
And we could see why. So a title to unregistered land is not only shown by possession of the title deeds, but also by the seller demonstrating that he has title by showing what we call a good root title, which is going back at least 30 years. So a transfer of title to land is completed in a two-stage transaction. You have the agreement for contract for sale, and that binds the vendor and the purchaser to complete the transfer. And under the agreement for sale, the vendor has to produce for the purchaser an abstract of title showing evidence which goes back to 30 years. The root title can be a conveyance, it could be a mortgage, it could be an assent. You know what assent means, right?
Yes.
Assent is when you transfer land from one of the personal representatives.
Through death.
Right, through death. and you have a conveyance, which transfers the title to the legal estate from the vendor to the purchaser. And the conveyance has to be made by deed. So I could give you a good example too of unregistered land. I know of a lady whose grandparents own almost 15 acres of land in one of the Caribbean islands. So the grandparents had died. The parents, when they were, when this person was like in their 30s, 40s, moved to New York. And only recently, they decided that, guess what? We have all of this property in Turks and Caicos. We need to go and see what we can do with it. Whether we're gonna sell it or build something on it, farm on it. So why won't you tell me what happened? What do you think happened? What happened when they went to search for this land?
Something was there. Somebody occupied the property, probably.
Yeah, somebody taking it over.
Yeah.
Someone had taken it all 15 acres gone.
Wow.
All they made was one phone call. And of course, all you do is press one button.
Right, because they have a registry of,
Yes,
they have
they do.
registered land, right?
Yes. And the property was gone. Cannot get it back.
So didn't they have papers, conveyances for this land or some type of deeds for it? What would have happened to that?
It's too late. When the notice goes in the paper, that is notice to the world. If you are not paying attention that someone is acquiring the title to this property, then you lose it. You trying now to claim a piece of property 40 years later. This person was farming on that land all those years. The land was gone. Do you really want to spend money to fight that? And that's why I always tell people, if you own land, you have to always watch, especially if it's vacant. You have to read the papers. I could give you another example.
Sorry, what time frame do they give you to respond?
I can't remember how long it's when it's published. How long you have in order to make a counterclaim. I'll have to look that up for you. I can't remember off my head. But I know of an individual that applied for a mortgage, right? Applied for a mortgage and use their vacant land as collateral. 2 acres of prime property. Mortgage has been paid off now for over 10 years. Never went to the bank to get the property deeds back.
Jesus.
That's right. Never went back. Prime property. Now they're just trying to find out what's the next steps to get it from the bank.
So
Wouldn't that have been registered once they did the conveyance? Why they may not have the physical title conveyance in their possession, but the registry should have a record of where it was conveyed to them and the mortgage was paid off, eh?
Yeah, that was my question as well. Like when they would go to do the title search, wouldn't they see that there's a previous owner for the same property? How did that work?
Well, right now, I don't know if anybody tried to claim it or anyone has built on the property. Because I'm telling you, it is prime property. This person has never gone back to look at the property in 10 years. But they don't have any documents for this property. It's held by the bank.
So it was never conveyed to them, Ms. Archer?
They needed it to be conveyed. No, they got a mortgage and they used that property as collateral. They paid off the mortgage, but never went back to get any documents. So that means
So-
they never did the satisfaction.
Right. So in that case, then the bank, it would have been recorded that the bank still had ownership of this property.
Yes, the bank still has ownership. But I told them they need to go and make sure no one has quieted that property. Because in this area, I see more roads are being built, more subdivisions are being built, and this is prime property. Close to the ocean. Who forgets property? I don't understand.
That's crazy.
Yeah, it is. A lot of people don't want the hassle. They don't want to be bothered. But then do you want to lose 2 acres of prime land?
Hell no.
So that's the part. So based upon what we covered today, you know that once you purchase a piece of property, you own that property, you have possession, exclusive control, but in reality, you only have an interest in that land. Once you own it without a mortgage, you own it fee simple absolute in possession. You hold both interests. Once you mortgage the property, you only have an equitable interest. The bank takes the legal interest in your property. You know that you can own a property in 2 different types of ownership, joint tenancy or tenancy in common. And a lot of people don't read the deed when property is transferred to them to know whether or not it's actually joint tenants or tenancy in common. And we know that with leasehold, your lease cannot exceed the maximum time that's given to the first leasee. And even though it is lease, the leaseor still has the fee simple absolute in possession because he's really only leasing a time. So any questions? All terminology is understood
For the most part. Mhm.
for the most part.
Yes.
I can need the recording.
So you need a what?
I can need to listen to this recording.
All right, so you have time to read it over. Any questions you have, write it down for next class. So next week, we're gonna do module 2, which is understanding the conveyancing process. So we won't be going over what words mean anymore. We actually going to go into the topic. So I want you to really get familiar with it because as we move into module 3, and we talk about different types of mortgage, you have to have an understanding of equitable interests, legal interests, freehold, lessee, lessor, the terminology. Whether you own property, when you own it, what does that mean? If you have title, what does that mean? What does it mean when you have good root title? What do you need? What documents do you need in order to say I have good title? So you gotta, if you don't understand the concept, then you need to take your time, read it over, go over it again so you can understand. So when you go through the other chapters, it's much easier for you to understand what it is that they're talking about. Remember, you don't own land. You own interests in land. And by ownership, it means that you have rights over that land. But you do not own that land. That land belongs to the crown. Okay?
Okay.
Yeah.
Okay.
Okay.
All right, so I'll give you enough time to read over, and then we will begin next week on module 2.
Ms.
Go ahead.
Archer, one question, please. Let me just clarify something that you said earlier. So like, if you own the land, but you do not live there, you do not have possession. Is that what that's what you meant?
Yeah, you don't have. Possession means that you're actually on it.
Right.
And you're controlling it, right?
Correct. So
but possession can also mean ownership.
Right. I understand that. Yeah. Possession could also mean ownership, but if I don't live there, I have the interest, but I don't have the possession of it. Is that correct?
Right, because you could have rented it out.
Okay. I understand now.
Right. Because remember now, once you own a piece of property, you have rights. And that right entitles you to rent, or it entitles you to sell it or give it away as a gift. You have that right. So possession just means that you have control over it. But possession doesn't mean title. So if you're in a landlord and tenant relationship and you're renting a house, you have possession, but you do not have title. So that's why they say when you rent your house or you rent an apartment to someone, they have exclusive possession. That's what that means.
Okay.
You can't just go and walk in someone's apartment and say, oh, I'm here to check things out. You could put a clause in the contract which says that the landlord has the right to check periodically for a specific reason. And it should have a clause to say that you have to make arrangements, but you can't just go in someone's house when they're not there. Because that is not exclusive possession.
So that is why when persons rent out their building or whatever, they can't, and they're not paying you, you can't just have them evicted.
No.
To go through certain channels in order to do that.
Yes. Because they have exclusive possession.
Okay.
So that's why whenever you draft a contract, you have to be very careful how you draft it. And be mindful that if your tenants is a family with children, you cannot put them on the street. You have to give them sufficient time to find suitable accommodations.
So
you
now
can't just throw them out.
If I was to draft it, what clause would I put in there? You said you have to be careful how to word it.
Yeah, what I mean is that you can't say after skipping 2 months rent, you have to move if they have children.
Okay.
You have to give them suitable time to find adequate provisions.
Okay.
You just can't do it. Because I know during COVID, a lot of landlords tried to evict tenants.
Yeah.
I saw on the commercial front on downtown. I don't know whether the tenants didn't pay for 6 months or 7 months, but they packed up and left.
Okay.
So, Miss Archer, the agreement between the tenants and the landlord versus, is there a law, a tenant and landlord agreement in law? Like, does that?
There's a landlord and tenant act.
Okay, so that would supersede any agreement that the landlord would make with the tenants then. So if it does not agree, then the landlord act, or the act that you speak of, that will take place, that will take precedence.
Yeah, because that's the law. Because normally between a landlord and tenant, the only thing you're saying is, this is when the contract begins. This is the duration of the contract, unless it's an open contract. And then you say, these are your responsibilities. These are my responsibilities. This is when you should pay. And then you have, right, and you have things like no cats, no dogs.
Right.
You may stipulate whether or not they could paint inside of their own choice, or whether they need permission to do certain things. See, because under the Landlord and Tenant Act, Section 3, you can bring an action for rent that is in arrears.
What's the last part? I didn't catch it. You
Now, I'm
can.
saying that the law allows you to bring an action if the rent is in arrears. You can't take them to court. Not
Okay.
saying you're going to get paid, but you can take them to court.
Okay.
But the Landlord and Tenant Act will still apply far above what the tenant and landlord contract would have been contracted.
It depends. It depends. Because don't forget now, a contract is a binding agreement between two parties. This is what you agreed to.
So if they agree to something that is not spelled out in the Tenant and Landlord Act, once as a tenant, I can show that once as a landlord, I can show that my tenant agreed to these terms. Can I then take them to court for that, even though it's not in the Tenant and Landlord Act?
Then you, what you mean not in the act?
Okay, like if there's a clause in the tenant and landlord agreement, but it's not in the act. It contradicts the act. Does the tenant still have a right to pursue whatever, I guess?
Okay, so you it's two different things. One, as the landlord, you wrote the contract. So once you go to court, the court always goes on the side of the other person.
The tenant.
Yes, it goes on the side of the tenant because you wrote the contract.
Okay, I understand.
So you always have to be careful when you draft the contract, because the court looks to the person who drafted it, because it's going to say, this is what you put in the contract. This is your agreement.
But if the person or the tenant signs it, that doesn't mean that they read it and agreed to it as well?
Ignorance is no excuse. So once you sign it, it is assumed that you read it. That excuse doesn't work. But if you wrote it, you cannot turn around and tell the judge that this is what I meant when I wrote it.
Right.
It will be construed against you because you wrote it.
The lady who was speaking first, I think she was saying because there is a landlord and tenant act, me being the landlord, if I was to draft up an agreement between me and my tenant that is slightly against what the act is actually saying, and the tenant agrees to it, could I still bring that to court to fight? If you understand.
Yes, you can. Yes, you can. Because that's the contract. That's what you agreed.
Right.
Now, it's whether or not that whatever's that clause is not too egregious, which means it really doesn't make any sense.
Okay.
Or when you read it, it's not fair. Then it will be construed against you.
Okay, even though the tenant agreed to it.
Yes.
Okay. Making sure.
Yeah. You can't just say, okay, this is what we put in. Yes, they agreed to it. But when you look at it in a holistic point of view and using common sense, and then don't forget now the court construes these things by words. So it's going to give the words its ordinary meaning. So in their view, the clause or the provision in that contract may not make any sense.
Gotcha.
So they'll construe it against you because you wrote it.
Wow.
So that's why I say when you write contracts now, you notice a lot of people who write leases and stuff, they try to put them in the most common words as possible so that there's clarity.
Right.
Because you can say in the contract, no pets, right? So I bring my monkey. And then you say, but I said no pets. But I thought you meant cats and dogs. My pet is a monkey. This to the court will say, well, you have to define pets. What is a pet?
Wow.
A pet is anything that has been house trained.
So then you'd have to say animals.
It depends on the word you're going to use. So if you say animals, would that include birds?
Jeez.
Okay.
You say you have to be specific, so a cat, dog, monkey.
You'll be listing animals for days.
Yeah. Well,
And then hold on. And if you list animals, and animals you listed have 4 legs, and I can bring one that have 2.
Yeah, that's true.
Because it wouldn't fall into that grouping. Guess a lot.
All others except human beings.
Let's look how some people just have they lease and they say no children allowed.
Oh yes, I've seen that a lot.
Yeah. Do you know why they do that?
Because they think children are going to destroy the place.
Yes, wear and tear, and the adults are just as bad.
I'm telling you.
To do it.
Some cases worse.
Yeah, in some cases they are worse. In some cases they are worse. But yeah, landlord and tenant is a different topic from mastering mortgages. They have different rules in law.
So in short, could you give us a rundown what we would have covered today? The property ownership, what is right of using?
Mm-hmm.
I know right of property. I know that was just you say list. There was 3 of. I try to find my bearings. So it's property ownership, I know you had classes, ownership, something you said, ownership of something, and then easement, restrictive covenants.
Okay, when someone say they have property, it means that they own it.
Right.
And ownership means you have rights. And rights, when we're talking about property, is 3 rights. You have the right to use it and have exclusive use of it, or you have a right to profit from it, which means you can rent it out, or you have the right to alienate it. Alienation means you transfer it to someone else by selling it. You could transfer it by gift. You could lose possession of it, but you don't lose title. So losing possession means that you lose control. And losing control means that you more or less, you don't have that right no more to exclude certain persons from your property. And then I said that there are other rights that come with property ownership. One was easements, which is a right over a piece of land which attaches to another one, is for their benefit. And one is profit. That's a right to go on to another person's land and diminish it by taking something from it. Maybe you go on another person's land to use water from a stream. And then the other right, which is restrictive covenants, which is more or less like a contract, but you use it in law because it's a covenant and is enforceable against all of the successors entitled to that land. So when you say you have title, title is what we call the true ownership. So instead of saying ownership, you say you have title. So you can say you own a bicycle, but you don't say I own the land. You say I have title in this land. And with that title, you have your possession. And by having title, it means that you are able to produce the documents showing that you have that exclusive possession and that right to be there. And then when you speak about ownership and property, property could be classified in different ways. Property could be real property, or it could be personal property. Real property is having that freehold interest. Freehold interest means that you own it fee simple absolute in possession. Personal property can be divided into 2. You have chattel real and you have chattel personal. Chattel real is having a leasehold interest, and chattel personal means cars, boats, jewelry, and furniture. You can take chattel personal and you could subdivide it into 2 choices: choices in action and choices in possession. Choices in possession is personal property. Books and computers and clothes, jewelry. Choice in action is property that doesn't have any physical existence. So that'll be the copyrights and goodwill. And when it's a bank, that'll be your insurance policy or your shares or your debentures. So there's property, there's ownership of it, there are rights that goes with it. And then you have different classification of property. Then we went over what is land. And we know that land is the building on the property. It doesn't include any fixtures. It doesn't include paintings. It doesn't include crops that you grow on the land. Land law relates to rights over land, not the land itself. The crown owns the land. What you actually own is rights. So you have a legal right and you have an equitable right. And your legal right could be a legal estate or a legal interest. The legal estate gives you a right of ownership. So you have the right to possess it and occupy it. That's freehold. A legal estate can be a freehold estate or a leasehold estate. Freehold means fee simple absolute in possession. You own the land free and clear. You don't owe anybody on that land. Leasehold means that you have a landlord-tenant arrangement. And each lease cannot exceed the period for the very first lessee. A legal interest in land is a right over land which is given to a non-owner. So even though they have a legal interest and they are the non-owner, it gives the non-owner a right which is less than the actual possession of the legal estate. So a permanent right of way over a neighbor's land gives a non-owner the right to cross that neighbor's land, but he doesn't take possession of it. That's a legal interest. And then I gave you some examples, such as easements and right of entry. And equitable interests are legal rights. And they are valid against anyone who has notice of those rights, whether it's actual or constructive. So when you obtain a mortgage, you get an equitable interest. And that equitable interest in the mortgage is your equity of redemption. And that's the right of the mortgager to redeem the mortgage property by paying off the debt. You can have an equitable charge. And this is when you take your interest in the land and you use it as security for a loan without creating a legal charge. And then your other interest could be a restrictive covenant. And that's where in the agreement for the land, there is a promise to restrict the use of the land for the benefit of another person who adjoins that property. So when you speak about ownership and you speak about land, you're talking about having both a legal and equitable ownership of a legal estate in land. And that legal ownership gives you a legal title to the estate and the equitable or beneficial interest in land. And you can have your equitable and legal interests being owned by different persons. An example I gave you was in a trust. A trust is a legal arrangement where the settlor or the donor or the grantor conveys, transfers both legal and equitable interests to the trustee to manage and administer the trust for the benefit of the beneficiaries, of whom the settlor, grantor, donor may be one. That is a beneficiary. A beneficiary has the equitable interest in the assets of the trust. So in that in that example, in a trust, the legal and equitable interests are separate. By being an equitable, having an equitable interest in the assets, that gives the beneficiaries the right to sue the trustees for breach of contract. Then next we spoke about co-ownership, which means that you can own a piece of property, or you can own land by yourself in fee simple absolute impossession, or you can own land with someone else, which is joint tenancy. If it says in the conveyance that this land is owned by these two persons, and there's no separate, no distinct shares, that means that when one person dies, the other person takes their share. If it says that two or more persons own the land, and it actually says, this is how much one person gets, this person gets 1/3, this one gets 2/3, then it is tenancy in common, and there is no right of survivorship. Their personal representative, depending on whether they died testate or intestate, follows the distribution as to who inherits that property. Remember, testate means that the person died with a will, and so the executor or the executrix then follows what's in the will. If they died without a will, then they died intestate. The administrator, who can only act after the probate has been granted, follows the rules of intestacy, which is settled in the Inheritance Act. So you own land. In the Bahamas, land is unregistered, which means that if you want to know if you have good title to land, you're going to have to do research. And you have to go back at least 30 years. You're going to look for abstracts of title. You're going to look for conveyances. You're going to look for mortgages. You have to go all the way back and do all of your searches until you come to a good title. If you're purchasing a piece of property, the first step is you always have an agreement for sale. And that vendor has to be able to produce an abstract of title that goes back to that 30 years. And that root of title, going back 30 years, is either it's stopped, either it is an assent, which means that someone died and the personal representative has transferred the property to the new legal owner. So the conveyance transfers the title to the legal estate of the seller to the purchaser under Bahamian law. And then I said that when you talk about land law in the Bahamas, being unregistered land, you have a series of legislation. You have the Conveyancing and Law of Property Act. You have the Law of Property and Conveyancing Condominium Act. You have the International Persons Landholding Act, Registration of Records Act, Real Property Tax, Stamp Duty Act, VAT, Quieting of Title, and Borrowers Protection Act. All of those concern land in the Bahamas.
Ms. Thatcher,
Now I know it's clearer than mud now, right?
yes, it is. I just have one question though.
Go ahead.
What is the difference between a conveyance and an assent? Do they carry the same type of title? If you understand what I mean?
Yeah, the assent is just when a person dies. It's just a document to say that the property has been transferred to you.
So it takes the place of a conveyance because it only operates under death.
Under death, yes.
Okay, I understand now. Thanks.
If I could have found mine, I'd have been able to share it with you. I'll still see if my brother has his own, so I can scan it. So you can see the wording of it for next class. I'll send him a note.
Okay, thanks.
Yeah. All right, so it's clearer now. So you understand that. So we can now go next week and start talking about conveyancing the process. I didn't ask if is anyone in class in this business of real estate or mortgages?
I am Vanchon Brennan.
Oh, okay. So what do you do?
I've been in banking for 25 years, former managing director of Finco, now business lead for Bahamas Collateral.
Oh, what does that mean?
Responsible for all of the collateral in RBC in the Bahamas, Turks and Caicos, and Cayman.
Oh my God. What a job.
Yeah,
Is
so
it exciting?
it is very exciting. I took it on as an opportunity, but knew mortgage lending, but didn't know too much of the depth of conveyances. Some of the stuff that you mentioned tonight was new to me.
Mm-hmm.
Relates to interest in property and not owning property. But just wanted to deepen my knowledge and as the says, master the mortgage product.
Okay, all right. That's good. Anybody else?
Richard F. Pintard. I work at Fidelity Bank downtown. I will be doing mortgages soon directly. I've done a few in the past, but I wanted, like she said, to have a depth understanding of the process.
Okay.
Mhm.
All right.
Then Dira Williamson, I'm at Commonwealth Bank. I used to work in the securities department. That's where I started off learning about mortgages. I'm now in our inspections department where we go into the branches and actually inspect and make sure all the collateral and everything are in place and is in order. And like the other two ladies said, I also want to advance my knowledge on the topic.
Okay, all right. That sounds good. Well, as we go through the chapters, of course, if you want to make clarification, or you want to add, feel free to join in. Just in case there's something you wanted to expand on or something that your organization is doing that's different from what we have in the manual, feel free to share. Okay? Because we're all here to learn. So, okay. So that sounds good. We have three experts here. That's what I'm gonna call you all, the experts. All right. So I leave that with you all. I'll tell you now in case I forget to tell you that for the final exam, my portion is normally short answer questions and not multiple choice. Just so that you know.
Noted.
Okay. Noted. So don't be shocked.
So no essays will be required, just short answers.
I could decide.
Please, please.
I could decide. It could be either way. I could decide. I don't know. It
First one.
depends.
Let's go with the first one.
Well, you know, I have to challenge those three, you know.
I'm one of the three.
Yes, I have to challenge you all. I can't just make an easy exam. No. I have to put some challenges there. I need you to think. So yeah, short answers, maybe essay, I don't know. I'll make up my mind yet at that time.
I've been out of
All
school
right.
for a very long time.
You been a what?
Been out of school for a very long time.
That's all right.
I
That's all right.
got to.
That's all right. So enjoy the rest of your evening. I'll see you at 6 o'clock next week.
Will
Good
do.
time.
Thank you.
Okay.
Thank
So
you.
good night.
Good night.
Okay.
Thank you. Good evening.
Okay. You're welcome.
Bye. Thanks. Bye-bye.
Yes. You're welcome.